Alex Jones, you may or may not know, he's been banned almost everywhere, so maybe you don't know him, but he is taking a free speech issue up to the Supreme Court, and it has now been docketed, and they've set a response deadline. So you may remember this. Alex Jones, of course, the purveyor of Infowars.com, very provocative guy, talks a lot about conspiracy theories, talks a lot about the news that many people think are conspiracy theories, but no, that's just the news. He also talks about sometimes, little things that can be very provocative that lead to him being canceled. And that was the case back when he was talking about Sandy Hook, that shooting that took place many years ago that he said was essentially fake. And so this article came over from newstimes.com. They give us some background here. Alex Jones argues that Blood on the Streets rant against the attorney of the Newtown families was protected free speech. And so this happened some time ago, this Newtown family story. And it says here, extremist Alex Jones has appealed to the U.S. Supreme Court, arguing that his infamous rant, now called the Blood on the Streets rant, against the attorney representing the families who lost loved ones in Sandy Hook was protected free speech. There's a little bit of a backstory here, but Alex Jones goes on these mega tirades, and he says a lot of provocative things. I mean, I think I heard him say one time that there were interdimensional space aliens who were reptilians who were populating our Congress or something like that. I mean, he was on the Joe Rogan show. He had a little tequila, had a little marijuana, and then boom, the guy's off for like 4 hours. It's hilarious. It's excellent entertainment, by the way, but it's not available anymore because he's been banned from virtually everything. So back when we had the Sandy Hook shooting, one of his conspiracy theories was the allegation that the whole thing was faked, that everybody was actors and the whole thing was orchestrated by the government as a false flag attack in order to pass some gun law registration or something like that. Obviously not true. Obviously, that's not something that I endorse. I don't believe like Alex Jones does, or I think he's modified his opinion now. That was a prior opinion, and now he's saying, yeah, you're right, it did happen. I'm sorry about that. But what he is saying is that in prior litigation, he was found to be responsible for defamatory statements, and he was sanctioned to pay a bunch of money. He's taken that up to the Supreme Court and saying, no, it's protected free speech. If I think that this was a fake thing, I should be free to say it. And so now that we have a little bit of a backdrop to that story, let's get back into this. So he says it was protected free speech. Norm Pattis, high-profile New Haven attorney, calls the sanctions that Jones received back in trial court in 2019 an unprecedented attack on freedom of speech, a direct frontal assault on the First Amendment itself, because what Jones did not constitute a legal threat. And as you know, on this channel, we talk a lot about free speech. I think that speech in and of itself is not dangerous speech. I know it can be offensive. I know it can be insulting. I know it can be hurtful. I know it can trigger people. But I tend to think that people should be able to say what they want. If somebody thinks something is a bizarre conspiracy theory, they're free to express that, because that's what the First Amendment protects. It protects hate speech. It protects dangerous speech. It protects the speech that people don't want to hear, because you don't need to protect the stuff that everybody's okay hearing. You got to protect the dangerous stuff that pushes the line to the margin. Unless, of course, there's an articulated exception there. You can't yell fire in a crowded theater. You can't make a true threat towards somebody. Those types of things are not protected speech because they implicate other principles and other rights and remedies. You are protected from being trampled to death in a crowded theater because somebody yells fire. Okay, but if somebody thinks something and they want to express their political opinion or their interpretation of facts and events, I think that should be protected. And so does Jones's lawyer. His views on the judicial process and the conduct of its various participants are core political speech protected by the First Amendment, regardless of whether he expresses them with Shakespearean eloquence or with quintessential American vim and vigor, he wrote in the appeal. Courts are not above the Constitution. They can transgress on constitutional liberties just as readily as the legislative or executive branches, particularly when they regulate the speech of those subject to that jurisdiction. Jones' appeal to the highest court in the country aims to overturn a decision by State Superior Court Judge Barbara Bellis that denied Jones what he considers a key line of defense in a defamation lawsuit brought against him by an FBI agent and 6 families who lost loved ones during the 2012 Sandy Hook shooting. Bellis's sanction, which was upheld by the Connecticut Supreme Court in July, came after a Texas-based businessman went on his Infowars broadcast with Pattis and claimed someone had embedded child pornography in Jones's emails that were turned over to the Sandy Hook families as part of the pretrial discovery process. Pattis argues in Jones's appeal that his call to arms in his rant was overwhelmingly hyperbolic, and that the only threat, if any, that Mr. Jones levied at opposing counsel was that of legal action. But by Wednesday, the families had not filed a response yet to Jones's appeal. Mattei expressed confidence in the lower court's ruling. Court after concluded that Jones has engaged in a whole picture of bad faith litigation against the plaintiffs from Sandy Hook. We expect the U.S. Supreme Court to see it the same way. Jones's appeal is the latest development in a handful of defamation lawsuits in Texas and Connecticut by families who lost loved ones in 2012 as a gunman shot his way into the Sandy Hook Elementary School, killed 26 first graders and educators, which was just a terrible story. I was still in law school when that happened. And it's just awful. So this is now sitting at the Supreme Court. Here is a screenshot from the docket. You can see this was docketed February 19th, so a couple weeks ago. It's Alex Emric Jones versus Erica Lafferty, 2021 case. Decision from the Supreme Court of Connecticut is now being appealed. Rehearing from the lower level court looks like that was denied back in 2020. And we have the petition for the writ of certiorari was filed February 12th, and there was a response date of March 22nd. So right before the Derek Chauvin trial is supposed to start. And so we want to go through this briefly. I think we all kind of know where this is going to go, but here is a petition for a writ of certiorari that was submitted into the U.S. Supreme Court of the United States. It is InfoWars, Alex Jones, Free Speech Systems, InfoWars Health, and others, Prison Planet TV, versus all of the people that we've already spoken about. Erica Lafferty, who we're going to learn is the daughter of a mother, the daughter of the principal who was at Sandy Hook, who got killed, along with all of these other people, of course, who are sort of survivors of the people who were killed. Petition for a writ of certiorari, filed by Norman Pattis, counsel of record. This is Erica Lafferty over from Twitter. She is the daughter of a woman who was the principal in Sandy Hook. And so now she's sort of an anti-gun or a gun reform, however you want to say it. Here's on her Twitter: background check, save lives. I am one of the 93% of Americans who support background checks on all gun sales. Okay, so sorry for her loss. Born 1985, same year as me, good year. But we're on different sides of the gun conversation. That's all right. So she's a party to this lawsuit. And these are the questions that are presented. So this is from Alex Jones's petition for a writ of certiorari. And let's go through it. We're going to go through it briefly. Here are the main questions. They say American courts possess inherent supervisory authority over their proceedings. So courts control the proceedings. They exercise that authority through their orders and sanctions, including civil contempt. They do not, however, possess unlimited authority, as the U.S. Constitution places limits on the exercise of their inherent power. Connecticut trial court sanctioned Alex Jones for extrajudicial statements, despite acknowledging that those statements were made in the course of a television and radio broadcast, that those are entitled to constitutional protection. The Connecticut Supreme Court altered this court's incitement and true threats exceptions to the First Amendment and functionally created an entirely new First Amendment exception that categorically applies to litigants simply because they are litigants. So what they're saying is, when Alex Jones was involved in litigation, he then said something that was now considered by the Supreme Court out of Connecticut to be off limits, an exception. He can't say those things, and so they're going to sanction him for saying those things. He's saying, no, it's First Amendment. I'm allowed to say those things, even if I'm in the middle of litigation. Whether the questions that the court is to be considered is whether a litigant's extrajudicial statements can be sanctioned when the First Amendment otherwise protects his speech and where there was no order providing prior notice of what speech was sanctionable. So if you're in the middle of a lawsuit, can you go on your TV show and call your opposing party a moron? Alex Jones saying, yeah, you can, in fact. And the court, according to Alex Jones, is saying, he's saying that we had no notice that I couldn't say those things. So normally it's protected free speech. Just because I'm in litigation doesn't make it less protected speech. Supreme Court, what do you have to say about that? Question number 2, whether a trial court's warning of the possibility of imposing the same criminal sanctions on a litigant for an unrelated matter is sufficient notice that a subsequent matter under the 14th, for a subsequent matter under the Due Process Clause. So another question there. Parties, we already covered those. Corporate disclosures, covered those. Petition for a writ of certiorari. First Amendment guarantees freedom of speech. We know it's not absolute. Court may impose sanctions for speech falling within certain prohibited categories, things like fighting words, incitements, true threats, of violence, incitements to violence, and defamation. Those are all exceptions. Courts have the authority to enforce their own rules, as in cases of attorney discipline for speech in violation of those rules. However, little case law exists on the power of courts to sanction litigants for extrajudicial statements, particularly for otherwise protected speech made outside the courtroom or lacking a connection to a court procedure that is uttered over the course of a television talk show. In this case, Connecticut Supreme Court sanctioned Alex Jones, and they refused to rule on a motion to dismiss a lawsuit. The sanction was entered without meaningful notice, no opportunity to be heard. Neither Jones nor the rest of the petitioners received any notice about what the trial court would allow and not allow. They call this an unprecedented attack on the freedom of speech under the guise of the inherent supervisory authority over the litigants. So they're saying that Connecticut Supreme Court is sanctioning him for making statements that were made during the course of the litigation, and they're calling it their inherent supervisory authority, which you might say, okay, well, the court can govern that, right? They can govern the motions, the proceedings, and how this unfolds in their court of law, but they didn't provide notice to Alex Jones that he couldn't go on his TV show and rant and rave. The Connecticut Supreme Court also crafts a dangerous new course in the First Amendment law by creating vague, highly generalized exception to the First Amendment protections, establish a basis for denying constitutional protection in unpopular and hateful speech. And then this goes on. Opinions, we've got jurisdiction. You can see here that they're saying that the Pennsylvania Supreme Court, all this stuff, it can go up to the U.S. Supreme Court. Statement of the case. Let's go through this. This is interesting. Statement of the case. Alex Jones has staked a fair claim to being the person most unpopular in Connecticut. Staked a fair claim. He knows it. He founded a nationally renowned media organization called InfoWars, broadcasts daily, reaches tons of people. Many people have labeled him a, quote, conspiracy theorist, as I kind of just did here. In the years following the 2012 school shooting, left 20 first and second graders and 6 teachers dead. Jones and his organizations entertained various controversial figures. They posited theories about whether the shootings actually took place or whether they were a contrived false flag operation, which is an event created to manufacture hysteria. Jones himself personally posed the same questions over the years, but he eventually stated that he no longer questioned whether the shooting actually took place. Respondents, parents, and relatives, they all are upset about it. Of course, they're suing him. Thus, respondents and petitioners claiming, among other things, they're saying there are unfair trade practices, defamation, and infliction of emotional distress. As we saw, Eric Swalwell also has some emotional distress, so we see that come up from time to time. Continues on. Respondents demanded that there was metadata associated with thousands of emails. And it looks like here they discovered that there was unopened child pornography, which the petitioners did not know about. Jones concluded that someone bent on doing him harm had sent the emails to him with hopes that prosecutors would eventually see it, exposing him to prosecution and incarceration. So then Jones quickly focused his suspicions on one of the respondents' lawyers, a former federal prosecutor with political ambitions. He chose to air his suspicions on his daily InfoWars television show. He informed his audience that someone had embedded child pornography and hate emails sent to him, excoriating him for his coverage of the Sandy Hook stuff. He said that he had to turn those emails over in discovery and that the former federal prosecutor had contacted the FBI and tried to get him into criminal trouble despite the emails. Jones then grew more and more outraged on live radio and television at what he perceived to be a deliberate attempt to cause him criminal trouble. He went into a profane and emotional tirade directed at the individuals he thought were responsible. He offered a $1 million reward for evidence that revealed who was responsible for sending him the child pornography. He also declared war and repeated his offer of a bounty directed at whoever sent the emails. You're just trying to set me up with child porn, he said. I'm going to get your ass. $1 million. $1 million, you little gang members. $1 million to put your head on a pike. $1 million. He uses a profanity word there. He says, I'm going to get your ass. You understand me now? You're not going to ever defeat Texas, you sacks of shit. So get ready for that. Oh, Alex Jones. All right. So despite his outrage, however, Jones unmistakably expressed that he only wanted people to act lawfully. Oh my gosh. And now I ask my listeners and everyone, you claimed I sent people. I never sent anybody, and I want legal and lawful action. But I pray to God that America awakens. Will Texas be defeated? You will now decide. This is war. Oh man, it's a good thing that he did not speak at the Save America rally, isn't it? A few days later, respondents filed motions asking the trial court to review the broadcast. Next day, the court held a hearing after argument. It sua sponte, that means on its own, the court elected to impose discipline without the benefit of a further briefing. They denied Mr. Jones and defendants the right to have their special motions to dismiss heard as a sanction, citing the court's inherent supervisory authority over the litigants. Expedited appeal, blah, blah, blah. All right, so Alex Jones went on an epic rant. I've got like tears in my eyes. That's so funny. Just going bananas. And his rants are hysterical, by the way. If you haven't seen one of those, they're something to behold. He goes off and he's got some serious energy behind it. So he goes off on this rant, goes back into court. Court just says, all right, that's a hard pass from us, brother. You're getting sanctioned. Now he's upset that his free speech in his television show, which I agree. I mean, I think he's free to go out and rant and rave whatever he wants. Now, when he starts saying, I'm going to put $1 million bounty on somebody's head, that's when you start to get into some tricky area here. And so we're going to see what the Supreme Court ultimately does with this. Reasons for granting the petition. They're saying that the Connecticut Supreme Court created a new exception to the First Amendment, which we don't like. We do not want new exceptions to the First Amendment. It's good as is. The Connecticut Supreme Court characterization of Mr. Jones' speech as an imminent and likely threat creates a new First Amendment exception. The Supreme Court fashioned an old rule that carves out a mixed motive analysis of its due process analysis and deprives litigants of any fair notice or meaningful opportunity to be heard on the merits. And so this whole thing has been submitted in front of the U.S. Supreme Court, and we'll see where it goes. The respondents are going to be able to file their response. It's due by March 22nd, so we'll continue to follow along on this story. And that's Alex Jones.